We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We want to discuss Land Law 1, and we want to discuss the term equitable and legal interest, the interest in land. Now, we want you to subscribe, share, and like our videos. Keep the comments coming, subscribe, and share to all the videos that we have uploaded for you on this channel, Law School Made Easy. Now, we want to discuss the concept of interest in land. Know this from me and the other people who have taught you land law, that interest in land can only exist in two ways. It is either legal interest or equitable interest. It is either legal interest or equitable interest. There is no any other interest in land apart from those two. There is a whole case of Williams versus Papaworth. According to this case of William, interest in land, unless there was something to restrict the meaning, must include equitable as well as legal interest. So those are the only interests we have in land. And in this video, I'm going to discuss the definition of equitable interest in land and the legal interest in land, and I will also discuss the case of Ndigejerawa versus Chizito and Kubura Mwana. Locus classicus for legal interest. Then in our subsequent video, I will do the forms of equitable. When do we say that someone has an interest that is equitable in land? That will be our next video about land law series. So let's now enter straight into what is equitable interest. Now, equitable interest in land is that interest that has not been registered. You have not registered your interest in land, but you have all things that show either you have bought or you have an interest in that land, but you are not registered. So you become an equitable, you get what we call equitable interest in land. What are some of the examples of someone who has equitable interest in land? We have tenants by occupants. You have heard about lawful occupants and bona fide occupants. Okay? They have interest in that land, but they have not yet registered. A right of a spouse in family land, that if you are married, your woman has a right in that land, in that family land. Of course, the other videos we shall do the video about family land. Okay? So, the RTA says that, under section 54, that the instrument is not yet effectual unless registered. So your instrument, your interest in land, when is not registered, what you have is equitable interest. You have a right on that land. You have a right, you have created a land. If you go and you buy, purchase of a land, if you purchase and you are given receipts, you have an interest in that land. Okay? There are examples, unlicensed lease. Such a person has interest in that land. Part performance of the purchase agreement. Okay? Taking possession of the land by the purchaser. You may take possession, so you have interest in land. execution of the purchase agreement. Okay? All these create an interest in land, and that interest is equitable. The beneficial interest before distribution of the estate. When the estate is not yet distributed, that benefit they give you, that you have a share in this land, that share is equitable. Okay? A mortgagee also has interest in land. So those are some of the formalities of equitable land. But in our interest, in our subsequent video, I am going to discuss with you each one of them: taking possession of the land, part performance of the purchase agreement, execution of the purchase agreement, unlicensed lease, right of a spouse in a family land, tenants by occupancy. I will try to elaborate more in a video about only and only equitable. But for now, allow me now cross to legal interest. Legal interest is when your interest in the land has been registered. Section 59 of the RTA provides that certificate shall be conclusive evidence of ownership of land. A certificate of title is conclusive evidence. So the moment you have registered your interest in land, okay, it means that you now own that land, because certificate is conclusive evidence. That is why it is hard to impeach a certificate of title unless there has been fraud. But we shall look at that in the next semester. Sorry, in our next video, that is for semester 2. Okay? Now, it becomes hard to impeach somebody with a title unless there were elements of fraud. Okay? So when you have the title, when you register your title, when your interest in land is registered, you become the owner of that land. You have a legal interest. You have registered your land. That land now has become yours. Let's look at the case of Ndigejerawa versus Chizito Kubura Mwana. Okay. Now, Chizito happens to be the owner of this land. So Chizito sells the land to Kubura Mwana. Both are now defendants in this case. Chizito sells the land to Kubura Mwana. 4 days after, he sells the same piece of land to Ndigejerawa. Listen carefully. Chizito sells the land to Kubura Mwana. 4 days after selling the land to Kubura Mwana, he sells the same land to Ndigejerawa. Now, Ndigejerawa, the last person to purchase the land, goes to the registrar to try and register. Then later, also, Kubura Mwana comes to register. They all fail because the instrument they had were not registrable. Their interests were not registrable. They all failed to register. Okay? And therefore, a principle was held that registration shall be conclusive evidence of land. Certificate of registration shall be conclusive evidence that you are the owner of this land. In the event you fail to register, when your instrument is not registrable, then you cannot claim this land is ours or mine. This takes me to discuss for you section 48 of the RTA. Section 48 of RTA states that, or provides that, the instruments registered first takes precedent. Now, assuming Kubura Mwana, who bought first, Assuming Ndigejerawa who bought the who was the second person to buy. If Ndigejerawa had the registrable instruments and he goes and registers, but remember it was Kubula Mwana who bought first, Ndigejerawa bought last. But if the one who bought last goes and registers and it is accepted in the registry that this land has been registered now in the names of Ndigejerawa, then Chizito, even when he was the first to buy the land, cannot claim the land has crossed hands, is now for Ndigejerawa, assuming they had succeeded in registration. So section 48 tells you that what comes first takes precedent under registration of land. The one who registers first their land, they have taken the day. You cannot come and claim. Because when you register, your title becomes divisible. Okay. So that is what we mean by legal right. So we are saying that fulfillment of all legal requirements in registration of land creates a legal interest, and failure to fulfill all the legal requirements in registration of land creates an equitable interest. We ask you to subscribe, to share, and like our videos. Until next time, thank you.